Good evening to everybody. Welcome to the today class of the International Human Rights Law. Karibu sana. Welcome to the class. And today that we are going to read the deliberation on the decided cases of the African Court of Human and Peoples. And please unmute and read what I posted on the screen. Anyone? Participants? Anyone can unmute and read what I posted on the screen. Haraka, quick. I think there is a problem, it seems. That's why they could not hear your voice. Yes, good evening to the students of the International Human Rights Law. Today online class on the decided cases of the African Court of the Human and Peoples by the Professor Dr. Mohammed Saheb Hussain, Course Coordinator, South Mwanza, Tanzania, East Africa. So now let us, without wasting the time, we'll go through some of the cases. And here, before I could proceed it, I would like to show you the cases from where I extracted. So these are the cases. We could see it. Almas Muhammad case law, it is here. I posted it. And you can see that the matter of the Almas Muhammad, Movinda and others versus United Republic of Tanzania. And the judgment given the 24th March 2022, the latest on the table of contents clearly mentioned over here. And the case summary also given. The court composed of the case summary that we'll see the parties are Almas Muhammad Moinda and 58 others here and after referred as the appellants, and are the Tanzania nationals and former employees of the Urafiki textile mills. They bring an action alleging the violation of the right to work as well as their right to non-discrimination. So the parties here clearly mention subject matter of the application, facts of the matter. It says that it emerges from the record that through the government notice dated 21 March 1997, the respondent state dissolved the Urafiki textile mills, hereinafter referred as the UTM, a public company, and retrenched all the applicants. All the applicants received the letters which indicated that the effective date for the termination of their employment was 31st March 1997. As a part of the UTMS dissolution, all its liabilities were vested in the respondent states, treasury registers, and these included those pertaining to the employees' terminal and retirement or similar benefit. So these were the facts of the case law. And the case law runs into the pages 3, 4, 5. Now let us see that what are the judgment would be given, how it will be dealt, and what is the reparations, and what is the applicant prayed the court to award them reparations. The respondent state did not make any prayers or reparations. Article 27 Subclass 1 of the protocol provides that if the court finds that there has been a violation of the human rights, human or the people right, it shall make the appropriate order to remedy the violation, including the payment of the fair compensation or reparation. Reparation means the fair compensation. The court, having found the respondent state has not violated any of the applicant's right, dismisses the claim for the reparation. So here the case law is dismissed because they did not violate any other thing, because they follow the process, due process of law. The applicant pays for the cost of the aspiration, while the respondent state did not make any submission of cost. So the operative part, for these reasons, the court unanimously on jurisdiction, they decided the case, declares that the application is admissible on the merits, find that the respondent state has not violated the appellant's right to work under the Article 15 of the Charter. Then again find the respondent state has not violated the applicant's right for non-discrimination under Article 2 of the Charter also. And reparation, dismiss the application prior for the reparation. Order each party bear its own cash, and sign, the judges are there here. Everybody sign, done in Arusha, the 20th day of the March in the 2022, an English and French case law version. So this is one of the case law which I would like to share with you, and this is the local case law. Then we can have another case of, for instance, you take, because there I made the several cases here. The European courts, Miss Shoban case law, Harald Mbarda case law, and then we will find the Joseph Mukwano case law. Then let me see the Joseph Mukwano case law, what it says. Yes, in the matter of the Joseph Mukwano versus United Republic of Tanzania, application number 021-2016, judgment given on 24th March 2022. Now let us go to the facts of the case law, what it says. The court composed of the Tikaya and the United Republic of Tanzania, represented by the many people who are there here. The parties is John Joseph Mukwano, hereinafter referred as the applicant, is a Tanzanian national and who at the time of the filing the application was incarcerated at the Butimba Central Prison in the Mwanza. Butimba Central Prison in the Mwanza after being convicted and sentenced to death for murder. The applicant challenges, among other, the violation of his rights to fair trial during the proceedings that led to him a sentencing. Of course, sentencing done in the domestic court, and when he was not happy by the decision of it, then he is approached the African court, that is the regional court of Africa, which is situated in the Arusha. The application filed against the United Republic of Tanzania, hereinafter referred as the respondent state, and which becomes a party to the African Charter on the Human and People's Right, hereinafter referred as the Charter on 21st October 1986, and to the Protocol of 10 February 2006. Furthermore, the respondent state on 29 March 2010 deposited the declaration prescribed under the Article 34 Class 6 of the protocol, hereinafter referred as the declaration, through which it has accepted the jurisdiction of the court to receive the application from the individuals, non-governmental organizations, an individual, state, other people. There you have every right to file a case in the African court. Now let us see the facts of the case law. It emerged from the record from this court that 11th August 2003, the applicant and two others stole items from the house of Professor Israel Katote, where they worked, and in the course of which they murdered him on 15 July 2010. The applicant was sentenced to death by the High Court of Tanzania at Bukoba for the said murder. Because I told you that first exhaust the local remedies, then we can approach to the African court. On 7th March 2013, the Court of Appeal confirmed the death sentence. Of course, the High Court, he appealed to the Court of Appeal, and the Court of Appeal has confirmed the death sentence of the appellant. Then the 30th April 2013 filed an application to the Court of Appeal to review the judgment. He made the review also 28 February 2014. The Court of Appeal struck out the application for the review for being lodged out of its time. Of course, because of the time factor would be there, they lodged and they dismissed they struck out it. And a subsequent request for the extension time was denied, and the 30th March 2015 on the ground that the applicant had failed to meet the legal threshold set out of the prevailing case law. So alleged violations were there. The applicant alleges that the Court of Appeal failed to consider some vital points of evidence and prejudiced to make its judgment review. Hence, he approached to the African court. Number two, the conviction was based on the alleged doctrine of the recent position of the alleged stolen article and the related confession extrajudicial statement. The third alleges that the Court of Appeal violated the right to non-discrimination. The Court of Appeal also violated the right to equal protection of the laws. So that was an allegation. Of course, the summary of the procedure before the court is the application was filed the 5th April 2016 and served on the respondent state on 10th May 2016. So prayer of the party is that applicant prays to the court that the quash both the conviction and sentence imposed upon him and set him at the liberty. That was the party's praise, and grant any other relief that it may be deemed fit with the circumstances. The respondent prays that the court to that the court does not have jurisdiction to hear the matter and the application is inadmissible. Number two, the respondent state has not violated any of the provision of the charter as alleged by the applicant. Number three, the application is dismissed on the cost and borne by the applicant. Of course, jurisdiction according to Article 3 of the protocol provides the follow jurisdiction. And a number of other things are gone over there. It runs to into the many pages, like we can see that pages, how many are there. Yes, it is a 24 pages judgment is given, total signed by all the judges. Then we will see that what are the merits and what the court decided and what it happened over there. So, reparations is concerned, the applicant praised the court to order the respondent state to set him at the liberty. He also requests the court to grant him the reparation, means the damages, the amount of the which should be assessed based upon the time spent in custody and the national annual ratio per citizens applicable in the respondent state. And again, he found the respondent state praised the court to find the appellant is not entitled to any reparation given by the fail to move the justify the claim. So that is the contention of the respondent state. The court notes that the Article 27 subclass 1 of the protocol stipulates that if the court finds that there has been a violation of the human right or people's right, it should make the appropriate order to remedy the violations, including the payment of the fair compensation or reparation. That is clearly mentioned there. The compensation will be paid if there is any human right violation will be there. And the court notes that since no violation has been established, the issue of the reparation does not arise, and here the applicant could not prove that there is a violation of the human rights depending upon the charter articles, and consequently the applicant prayer for the reparation be dismissed. So the overall what that say is the application made by the applicant is dismissed, and because he could not he did not prove it, and he failed to prove the violation of the charter was there. So that was the operative part. For this reason, the court unanimously decided to dismiss the objection to the material jurisdiction and declares it has a jurisdiction, admissibility is concerned, uphold the objection to admissibility of the application for the failure to the exhaust the local remedies in respect of the applicant conviction based on the doctrine of recent position. So the applicant has exhausted the local remedies because he filed the case in the High Court later on. The High Court make the conviction the same. Again, he appealed to the Court of Appeal. The Court of Appeal upheld the judgment of the High Court. Then he approached to the African court. African court says that he could not prove that the respondent state has violated the charter human rights violations, and hence the application is dismissed and no reparation will be paid. The cost will be borne by the each party. Dismiss the application to the admissibility of the application in other respects. Declares the application partially admissible. They say dismiss the applicant's prayer for the reparation and orders each party to bear its own cost. So that is the judgment of this case law. Yes, participants, are you ready? I don't think that you are making certain things. Then next we will see the another case law. What is the useful case law? We'll make it out. Okay. We have to follow that. If the case law is given, you should follow the Iraq model. If the problem question is given, you have to follow the Iraq model. You have to attempt the question. So Joseph Mukwana case law, let me see. I think we seen the Joseph Mukwana case law just now. Then Mashamba case law. Yes, Mashamba also, he has sent the one case law that is about the African Commission on the Human and People's Right, that is ACHPR versus the Republic of Kenya, application number 001/2012, judgment on reparations. So decision of the applicant court on the human and people's right. So the African court, they filed is an applicant is often. The applicant is the African Commission on the Human People's Right. The commission is the applicant here. African Commission on the Human and People Right, and here and after the applicant will say the commission alleged that October 2009, the Ogaika, an indigenous minority ethnic group in the Republic of Kenya, here and after we can say that the respondent state has received a 30 days of eviction notice issued by the Kenyan Forestry Service. So the eviction notice is given by the Kenyan Forestry Service to leave the Mao Forest. That is the name is the Mao Forest in Kenya. The commission filed the application after the receiving the 14th November 2009. The communication from the Center for the Minority Rights and Development and the Minority Rights Group International, both acting in behalf of the Ogaik, if I not be mistaken, how do you pronounce it? Ogiek, that is the one of the community of the Mao Forest. In the application, the commission argued that the eviction notice failed to consider the importance of the Mao forest for the survival of the Ogaik, the community, leading to the violation of the Article 1, 2, 4, 8, 14, 17, Class 2 or sabbatical 2 and 3, 21, 22 of the African Charter and the Human Rights People's Right. We can say it is a charter. So the court delivered the judgment on the merits of the application on the 26th May 2017. In its judgment, the court found that the respondent state has violated the rights of the OGEC under the Article 1, 2, 8, 14, 17, Sabbatical 2 or Class 2 and Class 3, 21 and 22 of the Article Charter. It also decided that it would be a rule on reparation in a separation judgment, invited the parties to the submission of the reparation. So they have admitted the case, and it is purely the violation of the Kenyan government of the state of Kenya for the eviction of the Ogek clan people from the Moho forest to go away from there, and hence if they want to get the compensation, they can file a separate case law in this case. It is also one of the important recent judgment given by the African court. So here the respondent state what the respondent says and what the third respondent states, what is the contention of the respondent, what is the contention of the application, what is the about the reparation, the court noted, the court acknowledged the compensation, and so on and so forth. So the case law runs into the roughly, yes, 9 pages. And in 9 pages, what is the outcome? As I told you already that as for the cost, the court ordered each party to bear its own cost, and Justice Blaise Chichikaya appended the separate opinion for the judgment. And further information is you can get it from the website. And African Human People's Right is they fight. They will try to give the justice to the party, those who are the regional court. So here the case law is clearly mentioned that is a violation of the charter, hence the Kenyan government is held liable to pay the compensation. Kenyan government cannot make the eviction, and if the reparation is concerned, okay, separate case would be filed over there for the reparation also. So this is the about this case law regarding the eviction of the Mao forest area. So I already sent you in the email, in attachment, and moreover, all the cases you could get it in the website of the African court also. So that is the thing which I want to share with you. The participants, are you there? Please, these are the cases one should have to read it, and that is the important cases. Then again, the Mogosi Moita is there. There is another Mogosi Moita case law. Yes, the Mogosi Moita Makungu. That is the case law versus the United Republic of Tanzania, application number 006/2016. And again, the reparation, that is the compensation, the table of contents is very much clearly given over there. And the court composed of the so and so people consisting of the courts and the parties already made. That is Mrs. Mugosi Moita Mukungu versus United Republic of Tanzania. Brief background of the matter is, in his application filed in the 29th January 2016, Mogosi Moita Mukungu, the applicant, alleged that the United Republic of Tanzania, the respondent state, has violated the right to non-discrimination, right to equal protection before the law, and right to fair trial under the Article 237 of the African Charter and the Human and People's Rights. The claim arose from the respondent states alleged the failure to provide the applicant with the certified true copies of the record of proceedings and judgments of the local courts, which rendered his conviction of the robbery with violence and armed robbery and cumulative sentence of the 30 years of imprisonment. That is the case law for that one. 30 years of imprisonment is made in the High Court as well as the Court of Appeal, and hence he approached to the African court because he exhausted all the local remedies. So on December 7, 2018, the court ordered the judgment of the which paragraph given clearly means. So this case law will, and the subject of the application, summary of the procedure before the court, and the side headings, and the prayer of the parties. The prayer of the parties, the applicant prays that the court to grant the following reparation. Number 1, Tanzania shillings, the 2 millions of Tanzania shillings to the applicant for the moral prejudice, and 20 million Tanzania shilling payable to each of his two wives, Mrs. Gadi Mogosi and Mrs. Nyangi Bageni, for the moral prejudice, and the 10 million Tanzania shilling to his mother, Niaki Bari Momani for the moral prejudice, and 10 millions Tanzania shillings on this brother and moral prejudice, and 5 million Tanzania shillings to each of his children for the moral prejudice. Thus, he made the total 9 um, praise they made. The respondent state did not respond to the application submission. So later on, what actually happened in this case law, let me see the judgment is concerned because it is signed by the many all the judges over there, and now, when you come to the pecuniary reparation, the pecuniary reparations are concerned, dismisses the applicant payer for the moral prejudice suffered by the alleged indirect victim. So, that is the indirect victim cannot get the reparation. Grants the applicant prayer for the material prejudice and awards him to be a sum of 5 millions of 5,807 thousands and 421 Tanzania shillings for that much only. Grants the applicant prayer with the regard to the moral prejudice and award him sum of 20 million Tanzania shillings and order the respondent state to pay the amount indicated under the paragraph 2 and 3 tax free as a fair compensation within the 6 months from the date of the notification of the judgment, failure of which it will be required to pay the interest or arrears calculated on the basis of the applicable rate of the Bank of Tanzania throughout the period of the delayed payment until the accrued amount of the fulfilled. So whatever the grounds would be there, the partial grounds were fulfilled by the applicant and he won the case, and the respondent state, that is the Union Republic of Tanzania, should have to pay it. Regarding the non-pecuniary reparation is concerned, order the respondent state to publish the judgment in the English and Kiswahili on the website of the Judiciary and the Ministry of the Constitutional and the Legal Affairs, and to ensure that it remains accessible at least 1 year after the date of the publication. So, implementing the reporting orders the respondent state to submit it to the within 6 months from the date of the notification of this judgment, a report on the status of the implementation of the orders set forth herein and thereafter every 6 months until the court consider that there has been a full implementation thereof. Order each party to bear its own cast. That means the case is won by the party who filed the application, the applicant, against the Union Republic of Tanzania. This is the another case where it is the African court has decided. Now we'll see there is a Mohammed Suleiman Marwa versus United Republic of Tanzania. Other case is there. Umar Mariko case law is there. Rajab Yusuf case law is there. Robert Richard versus United Republic of Tanzania is case law is there. And how the case law will come into the picture. And all these things that which I have taken from the website of the African Charter. Now let us see that share, we can make it out. I would like to show you where this African Charter is there. Okay. I don't know whether you could see it or not. Yeah. So this is the thing Africans. Okay, let me close this thing, then open the other thing so that we could know that it's a share. Okay, share the content, and I believe it is here. No, it is not there. It is a different one. Okay, let me go through it to see which is the case law. I think it is Google, and the African Court of Peoples and what videos? We don't know what videos. People's Right. Yeah, Arusha. Yeah, this is the African Court of People's Right in the home. Then you could see the cases here, latest cases. If you click it, and latest, yeah, you could find it here. Is it visible to you? Yes. Could you see on the screen what I shared? It is why it is showing blank. Share content. Yeah, share content it is. Yeah, now I think you can see. Yeah, now you can see that what are the cases there. So application 008-2020 Gabi Kodiat et Nabia Kodia versus Republic of Benin. This is another case law. It is in English. You can click it, you will get it. Then application 007-2021 and Tricoro, Sangare, and other 15 other verses Republic of Mali and application 022-2070 Harold Mablanda Muthari on his own behalf on behalf of the dependent Mablanda Movezi Vapala Munthali versus Republic of Malawi. There is a case law, and this we already dealt it. Mugosi Moita Makungu versus Unit of Republic of Tanzania. We did it. And the African Commission on the Human and People's Rights versus Republic of Kenya. Yes, this is the Kenyan. There is the they want to vacate it, one of the clan over there, and they cannot vacate it. The human right violation would be there. That we already dealt this case law. I posted to you in the individual WhatsApp as well as the email. And later we can see the Omar Mariko versus Republic of Mali. This is also one of the case law. And Rajabu Yusuf versus United Republic of Tanzania. It is also important case law, and we have to read it. The case law. I think I already discussed this case law, if I not be mistaken. Let me check it whether I have discussed it or not. Stop sharing. Okay, now let us see that whether I discussed this case law or not, so that I could know it. Okay, let me check it in a quick manner, so that you could know that what I am dealing is. Okay. Yeah. Like the HRL, we can make it out. Then yeah, because I already told you now 15 questions caseless, which I given the first semester, 15 cases which I gave you the second semester based on that thing and based on the course outline that the university and examination would be there. So one should have to read those cases. Then only we can make it out what comes here, what comes later, and so on and so forth. We can make it out. Okay, now let us see that how we can make it out. Yes. And Umar Mariko was a Republic of Mali. We already dealt it. We have not dealt it, but we said Joseph Makuano was a Republic of Tanzania. Yes, we covered it. And Stephen John Rutakikirwa versus United Republic of Tanzania. And we also made it. And I'm sure that you could, now you could not, because I did not share it. That's why you could not see the, yeah, I will share it so that you could see what I am sharing. Yes. So now you could see that what I'm sharing is. So these are all that case law that you could find it from the African court. Then Stephen John Rutakikirwa versus United Republic of Tanzania. This is also case law, local case law. Gojbat Haneriko versus United Republic of Tanzania. This is also one of the case law. The local, the Tobias Mango and another versus United Republic of Tanzania. And we can find it in the website of the African court. Then Muhammad Sulaiman Marwa versus United Republic of Tanzania. Then also we can find it in the, then we can also see the Anudo, Ochinge Anudo versus United Republic of Tanzania. This is also case law. We can get it from the net. And Kudio Kobena Fori, of course, is not a local case law, but we can just eliminate it. And yes, this is also local. Robert Richard versus United Republic of Tanzania. This is also one of the important case law. We have to study it in the examination point of view also. And Hamisi Shaban, Hamisi case law. Then this is also the United Republic of Tanzania. And then we can find it, the case law is Sadiq Marwa Kisase versus United United Republic of Tanzania. This is also one of the case law. We will be reading it. So total, I have sent you the email regarding the local case laws, including the Kenyan and including the other country case law also, which is important because the principle is very important in that case law. That's why that I sent to you, and I'm sure that it will be useful to you, and you read it and make the university examination a successful manner. And because I told you that I framed the questions in that manner, the first question is the problem based question consisting of the 40 marks, and you should attempt in the Iraq model, Iraq method. And the second question is the analytical question. I give the statement, then I will ask you to analyze your statement with the decided cases or authorities. The third question is mostly based on the case law. Any one of the case law which is the African court has decided over there, based on that thing, and I will make the two options over there. I give the two cases, then I made the or, then you have to apply, you have to attempt any one on the third question that is in the PFIRAC model. And that's the reason that I took the today classes in detail, that I am explaining you the number of the cases which I already dealt to you, and I sent to your email, and you read those cases and be ready for the exam. And the fourth case law that I alluded to is type the question. It depends upon the cases which I have given over there in the first semester, and the first internal assessment as the second internal assessment, total 15 questions, and total another 15 questions, total 30 questions in total for the both assignment, continuous assignment, and based on the course outline that I framed the questions. So in this way that you have to make it the questions and better concentrate on the African court case laws, which is primarily the where Tanzania is one of the party, and some of the very other case law which I have sent you in the email also, which also very important factor for solving the questions. So these are the cases which I want to make it out. And participants, there is no answer from your questions. So I dealt it all the things because I told you that what are the cases which I sent to you. So if you could happen to say Almas Muhammad, Moinda and others for say United Republic of Tanzania, I sent you in the email. Anudo Ochinga, Anudo versus United Republic of Tanzania also I sent in the email. And when you see the course outline and from the course outline also the questions will be framed, which is relevant to it. Then we will come to the point of again another case law is this is the 15 questions IHRL and 15 questions for the second assignment. And then we come to the matter Hamis Shaban alias versus Hamis Usad versus Union of Republic of Tanzania. Also you have to read it. Harald Mbalanda versus Munthali versus Republic of Malawi. This is also an important case law. And then we come to then I have given you what is the Iraq model, what is the PFIRAC model, how the questions will be solved. If the problem question is given, it will be solved in the Iraq model. If the case law would be given in the PFIRAC model or method that you have to follow it. The Joseph Mukwana versus United Republic of Tanzania that I gave in a detailed manner, this case law that I narrated. Then the Leford Makane versus United Republic of Tanzania, this is also a case law, one should have to study it. Then African Commission for the Human Rights, they also filed the case law regarding the forest evacuation. That is also an important case law that one should have to study it because that will be useful for the to understand how the African court has given the judgment. And Magosi Moita versus Mukungufu, that I already dealt it in the class now itself only. And you read at least one of the case law and come to tomorrow class so that we can have the deliberation on the cases so that it will be easy for you to understand what are the case says and how the violation would be there, what are the court contention, what are the applicant contention, what is the applicant prayer, what are the respondents say prayer, or what are the respondents contention, what are the issues raised over there, what are the prayers should be there for the both the side, applicant side as well as the respondent side. Then we can also say that the case law is Umar versus Mariko versus Republic of Mali. This is also a good case law where we can make it out what are the principles are involved over there. Then comes to the Rajabu Yusuf versus United Republic of Tanzania. This is also a good case law, which is where the second party, that the state, the respondent party is the state, that is the state of Tanzania, that is the Union Republic of Tanzania. Robert Richard, this also the very interesting case law, and we have to read it, and I dealt it in the class also, and you also dealt it in the coming classes still, because your exam is on the 14th, if I not be mistaken. Yes, up to the 14th, you can make the revision so that you could pass with the flying colors. And Sadvik Makwa versus Kisase versus United Republic of Tanzania. This is another case law which is decided by the African court. And here the sample question paper that I already sent to you, and the second 15 the test questions also I have sent to you, and the Stephen John Ratakikivara Kesla, that is, how do you pronounce Stephen John Rutakikirwa versus United Republic of Tanzania. So these are the cases that we have to study it when you want to make it out in your examinations. So local cases are very much important factor, because it gives what violations should be there by, and how the African court has decided it, and what are the grounds they made it over there, and how it will be dealt. We can clearly mention it. So from the tomorrow class, please make the point that you read at least one of the cases and come to the class, so that our class will be the participatory class, and we can make the deliberations. And I already posted over there to attend the class, and don't miss the classes. And if you miss the class, you miss many things, and you will miss the even a good score also. So with this, I would like to stop my today lecture. And thank you very much. Asante sana, nashukuru sana. Mungu akubariki na kukulinda. Then stop sharing. Have a good day. And